Well, good morning, everyone. Welcome here to the Minnehaha County Commission. We'll start the meeting with the Pledge of Allegiance. Allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Everyone to silence their cell phones, which is always a good reminder for me. Meeting documents are available for review down next to Commissioner Heiberger, and Craig is here this morning if you need a listening device. That will take us to routine business. I consider a motion to approve the agenda.
So moved.
Second.
Motion and a second. All in favor?
Aye.
Any opposed? Motion passes unanimously. Next item is a motion. I'd consider a motion to approve the Minnehaha Commission meeting minutes for July 2nd, 2019.
So moved.
Second.
Motion and a second. All in favor?
Aye.
Aye.
Any opposed? Motion passes unanimously. Next item is bills to be paid in the amount of $1,311,511.23.
Pay the bill.
Motion and a second. Any comments?
Madam Chair, I studied them, but my mind is discombobulated with the rain today.
Yeah, I think the vast majority of the bills this week are highway bills for a lot of road work that's going on right now. So, okay, so I have a motion and a second. All in favor?
Aye.
Aye.
Any opposed? Motion passes unanimously. Reports, there's the Mobile Crisis Team annual stats through June 2019. Always provides a lot of good information. I had a couple of questions, and Carol was helpful on that. So I'd recommend that for your review. Next item is personnel actions. I'd consider a motion to approve routine personnel actions.
Motion to approve?
Second.
Motion and a second. Any questions? All in favor?
Aye.
Any opposed? Motion passes unanimously. Item 6 is abatements recommended for approval. Chris Lilla, good morning.
Chris Lilly, Equalization. The first two are for Herb BV LLC. I've recommended these for approval. This is a house that was torn down and taken to the landfill. The only catch in this one here is that there was no RAS permit issued for this property, but the owners have provided me what I think is ample details. They provided me the landfill receipts of when they hauled that house to the landfill, the service disconnect order, and all of that stuff. So in my opinion, I think I have enough information to say that this house was in fact torn down. We just were unaware of it to take it off of the books at the time. And based on that, we have a date of when we can go back and calculate for an abatement. So in my opinion, I believe there's enough information to say that, yes, this property was not there and we continued to assess it.
Okay, any questions for Chris? I'd consider a motion.
Move for approval.
Second.
Motion and a second. Roll call vote, please.
Heiberger,
Aye.
Karski,
Aye.
Barth,
Aye.
Benega,
Aye.
Bender.
Aye. Motion passes unanimously.
The next two are actually veterans exemptions. Both of them are a little different. One's a veteran, one's a surviving spouse, but both of them qualified, just failed to make the application deadline. But as the law allows, if they would have qualified but failed to make that deadline, we're allowed to request an abatement. So I have no issues with either of these.
Any questions for Chris?
Madam Chair, I show 3 of these for veterans exemption.
It's 2 properties, but 2 years on one.
Okay, thank you. Make a motion to approve.
Second. Second.
Motion and a second. Roll call vote, please.
Karski,
Aye.
Barth,
Aye.
Benega,
Aye.
Heiberger, Bender.
Aye. Motion passes unanimously. So the next item is an abatement recommended for denial. Chris?
Yes, this one here is a little more complicated. Mr. Ettraim had gotten in contact with me and asked me about these here. So the situation with this property is, as the property stood on November 1st of 2017, which is our legal assessment date, it was assessed on a parent parcel, a house, 2.34 acres of land, altogether under a Marlon Conrad's ownership. On November 7th, 7 days after our legal assessment date, or 6 days after, Marlon had platted this 2.34 acres into 3 different lots. So we can't split it. We didn't know about it. It wasn't split by November 1st, so we have to assess it as a whole property. On December 4th, Mr. Ettheim purchased the spec home that was built on one of the lots along with his lot, and the other 2 lots were also sold somewhere in that same time frame. So as we move forward a year down the road, when the auditor's office is preparing the tax bill to the parent parcel, which is 61120, the auditor's office requested our office to do a breakout of the percentage of taxes due to each individual parts, because again, go back to November 1, it was one big piece, but a year later when the taxes come due, it's 3 pieces, one with the house and 2 other additional lots. So our office did the breakout of the value to show each part's percentage. The auditor's office sent Mr. Ettheim a tax bill. He feels that he should not have received a tax bill. He shouldn't have gotten a tax bill because he didn't own it on November 1st. It wasn't legally assessed, in his opinion, as of November 1 to his parcel specifically, which I don't disagree. We did not assess his parcel individually on its own merits. We had to assess the whole big parcel. A year later, when the taxes come due, we have to show what each parts, how they add up to the whole so they can be taxed effectively. So Mr. Ettheim then has basically challenged the position that he shouldn't have to pay the taxes, he shouldn't have got a tax bill. And in any event that he did, that he would be willing to take an owner-occupied levy. I have an issue with that. The owner-occupied, he didn't own it as of November 1st. He didn't occupy it. It wasn't his principal residence. He is not eligible to receive owner-occupied as it stood. No different than if I bought a spec house today. I can't go back and say, well, I should be eligible for owner-occupied. So that's the information. I am recommending denial on it, and I'm not sure if he's here to speak or not. Okay.
Wait just a second first. Does anybody have any questions for Chris? This is fairly complicated factually. Commissioner Karski.
So this kind of all evolves around the date. And that's
Correct.
that picture on that date, how things were.
Yep.
And that's how we, or your office has to
Correct.
do things, is based on that snapshot of that
November
date.
1st, how does that property sit? It was a house and 2.34 acres. On November 7th, it was a house and sitting on its own lot and 2 other lots platted after the legal assessment date. And then again on December 4th, Mr. Ettheim purchased his house and lot, which was a spec home. We have no ability to do anything with that. Then it falls to the auditor the next year on how do we tax it. We need the auditor, the value doesn't change for the whole, the taxes didn't change for the whole. All it was the auditor requested from us to say, this house and this lot share, this lot share, and this lot share all add up to what the whole was. And that's what it is, so.
Commissioner Heiberger.
I have 2 questions.
Okay.
So when they divided it out, did portions go to each one of those 3? No, they all went on his?
No, each
They
person
were-
got their, and again, I can't speak for the auditor's
Right.
office, but I'm assuming that all 3 new owners
Shared a portion of it?
got their own tax bill for a lot, and then a lot with a house.
And then my other question is, and I know state law tells us how we have to do this stuff, but why wasn't the bill given to the person who owed the property on November 1st? Or, my second one is I thought that when you buy a property, that's part of the
Closing?
closing that says that who has to pay the property taxes.
Generally it is, and I completely concur with you. I don't know, normally in my past, Conrad would have gotten the whole tax bill.
Right.
And he would have had to collect from each party, and generally that's done at closings.
Yes.
I'm not sure, again, I'm not privy to any of the closings. I don't know why that wasn't done.
But, I mean, that'd be just a question I have, is
Yeah.
that part of the closing? Is, because that's where that should be. I mean, I just went through a closing, and so
Right,
that's part of the
right.
closing.
90% of them will go through an abstract company or title company, and they will collect from the purchasers and hold that money until the taxes come due, and then pay for each person's share. I don't know why that wasn't done in this case. I don't even know if there was a closing agent
We
involved.
can ask that
Yes,
guy when he
yes.
comes up.
Any other questions? Okay, thank you. Just identify yourself and give your address. That'd be great.
Brian Etram, live at 509 Sarah C. Street in Garrettson, South Dakota, 57030.
Thank you.
So yeah, pretty much what Chris said, I guess. I guess a couple things though. it goes against South Dakota tax law on when the legal assessment date has to happen. This breakout happened well after the legal assessment date of February 19th, 2019. Those assessments have to be completed by the equalization office on March 1st, 2018. For whatever reason, the tax law was circumvented. It's not in accordance to that. And I don't believe I should be held legally liable for these property taxes.
Questions?
I didn't understand that.
The equalization office has to have their assessments done by a particular date.
Yes.
They never gave me an assessment. It was never broken out to me until February 19th of 2019, well after the legal assessment date, almost 11 months after.
But my thought is that this is from 2017 taxes paid in 2018, so you wouldn't have even gotten those. Or I got that wrong, Chris, sorry.
Yeah.
No, he's on point. The issue is November 1 of 17, we had an assessment. I have to send that assessment notice out in the mail by March 1st, which is the date he's referring to.
Okay.
So March 1st, an assessment notice went out again for the 2.34 acres, the whole big property. Then you move ahead a year when the auditor's office is calculating the taxes. That's when they requested that we give a breakout because the ownership has changed in the meantime. So we have to get the right taxes to the right people. That's what he's referring to, and he's stating that he didn't get an assessment notice for his share from my office. Well, we can't legally do that. That's why there's a breakout of taxes, and there's a law in place to allow the auditor, upon request, to break those taxes to the individual ownership. And I provided that law to Mr. Edheim. So as my office stands on November 1, I have to assess it. It changed after November 1. I can't change mid-year. I can't change ownership names to the parcels. That exists for the next year, for the 19 due and pay in 20, which he will get his own assessment notice now moving forward in the future. But the dates and timing of the circumstances, he was not directly notified to him, the assessment or the value of his property. That was notified to Conrad, or Marlon Conrad, the owner of the whole, because that was the timing of the events.
Commissioner Heiberger.
I have another question for Mr. Brandt.
Metro.
And that was what happened in the closing, because this should have been handled in the closing.
Yeah, no property taxes were handled in the closing at all.
Did you use a closing company?
Yep. Land guarantee and title.
I think I'd go back to them.
Yeah, I guess I didn't know of any law that allows the county to break out the property taxes well after the assessment date. And I don't know what law Chris is talking about regarding that at all. What is, I've got our email correspondence, I guess, and I didn't see that at all. You talk about a divided assessment?
10, 21, 35.
But nothing in that law says that you can go outside of the legal assessment date.
Commissioner Karski.
I just need a little bit better, so I understand the timeline of everything. November 1 of 17, this was one property.
Correct.
Okay. When did you buy the property?
December 4th, 2017.
Okay, so December 4th of 17, okay. November 1st of 18, it was reassessed for 3 properties, correct? Okay, so, just loud. The tax bill in question is for the taxes that were assessed in 18, payable in 19?
Correct.
So when you got assessed for the taxes in 18, that was based on the November 1st,
17.
I'm sorry?
November 1st of 17 is the beginning of our 18 payment.
Chris, I think you need to come to the mic. I'm sorry.
Yes, all right. So November 1 of 17 begins our 2018 assessment year for taxes due and pay in 19.
Okay, okay. So when he got the bill payable in 19, it was for the November 1st of
17, how it
ass-
stood that day.
Okay.
Yep.
But he bought it December 4th.
Yep. So the tax year, our assessment year starts November 1. The tax year actually begins January 1. And that's where the auditor's office will work on abatements for.
And
He
the
owned
rub for-
he owned the property the entire year of 2018 for when they come due in 19.
And Mr. Ettrheim, then the rub for you is,
You'll need to come back up to the mic, too. You guys might want to just
Sure.
both hang out at the mic for a little bit. Thank you.
the rub for you is that because when you bought it December 4th, you thought it should have been reassessed as of the purchase date? Or,
No, it
Help
was
me
done
understand.
well outside of the period. So I ended up talking to my coworker, Russ Hanson, property tax specialist at the Department of Revenue. I asked him, because I was trying to do a little bit of financial planning around February or whatever, called to the treasurer's office to see what my property tax bill would be for 2018 payable in 2019. Come to find out, they said, no, nothing's due. I looked it up on the website and nothing was due at that time. Then they said, you might want to call over to the equalization office. Got a hold of somebody. They said no assessment was done. Then I talked to my coworker about it and he said, well, it was an unplotted piece of land. They couldn't legally assess it. And that's where we're at, I guess. I'm getting an assessment when they couldn't legally assess it.
are we
I mean, I wouldn't
always-
even have been on the assessment rolls at all.
So my question then is from December 4th to 17, when you took ownership, what do you think you should have been paying taxes based on, or what are you being billed for, and what do you think you should have been billed for?
I don't think I should be, I mean, I think I should have received an assessment. And I should have gotten that value from the equalization office. It shouldn't have been last minute, we're just sending him a bill. I mean, it's not in accordance to South Dakota tax law.
If you will, I think our state's attorney has had an opportunity to look at this. If you could just explain to us a little bit about what you view as what the South Dakota law says on this issue.
Thank you.
Well, Madam Chair, I think that first and foremost, the board needs to understand that, as I understand the facts, and I think Chris could re-articulate this, is that the applicant purchased the house in December of 2017 and lived at the house throughout the time period for which now he's claiming he shouldn't have to pay any taxes merely because he didn't own the house on the date of the assessment, November 1st of 2017. So in other words, the applicant is requesting that the board apparently abate all of the real property taxes for 2018 payable in 2019 merely because on the date of assessment, November 1st of 2017, he didn't own the property. It was platted days after, and then he purchased it in December of 2017, lived there the whole time, apparently still lives there, and is now claiming that he shouldn't have to pay any tax because he didn't own it on November 1st. Well, the tax is a lien against the real property. And so we know that there's a statute in South Dakota that says that if an individual asks for the property to be broken down for a divided parcel, that the county can do that. So if the applicant wants to speak with the seller and ask and come to a conclusion with the seller about who should pay the real property taxes for the 12 months that Mr. Etrim lived there, he can certainly do that. We can contact the seller, I suppose, and tell the seller, Mr. Etrim doesn't want to pay the real property taxes for the year that he lived there because you were the owner, seller, on November 1st. We can certainly do that. At the end of the day, the property taxes are a lien on the real property, and the assessment of November 1st was used and applied to these 3 lots
the value didn't change as far as the assessed value. It was just spread across these 3 lots. I mean, I can't give legal advice on the floor, but I think that for all practical purposes, while Chris has articulated this is sort of a perfect circumstantial storm, I think the question before the board is something that Mr. Etrim has the ability to appeal. He can hire his own lawyer. He can appeal it without a lawyer. But we can't give him any legal advice, and I can't give legal advice on the floor. So I think at the end of the day, someone has to pay the taxes because they're due. And they're a lien, and I think that Mr. Etrim can go back to the title company if there was any question about the 2017 taxes payable in 18. I have to believe those were paid out of closing. I'm assuming they had a title company, because if the land was replatted, the taxes would have had to been paid. So I think Mr. Etrim has remedies available, but at the end of the day, for all practical purposes for the county, the taxes are due and owing, and somebody's gonna have to pay it, either the seller or this individual who purchased the replatted property.
Any questions? Commissioner Benninga?
Chris, why can't we go back to the title company and get the documentation that shows who paid for those taxes when the closing was done from the title company on November 1st?
I suppose I could ask them. I don't know that they would give to me. I mean, I have no legal,
Isn't that a public record?
not their closings, not that I believe. I mean, that's a private value document between the seller and the buyer. I don't know that I can ask them. I've never done that before. I can't say if I could or couldn't. The certificate of value is a public document that they are required to file with that says how much they paid for it and all of that stuff. But as far as the particulars of their financing, I don't know that I can request that. I can certainly inquire and ask them.
I'm sure that Brant could get that information.
I'd be willing to provide that information.
The question for me is, on November 1st, Mr. Conrad still owned that property, and if in fact you used a closing company, they would have collected taxes through that closing date of the sale to be able to satisfy the real estate taxes. And it seems to me that's what's in question. Who owns the property for that period of time? I mean, the time frame's not a total year, but if you're going back a year, you should be able to produce, if you will, that closing cost statement that shows that you paid the real estate taxes from November 1st or whenever the closing date was, and Mr. Conrad didn't pay him, or maybe he did pay him and hasn't paid us.
And just to be clear, because factually this is very complicated, we aren't talking about 2017 taxes payable in 2018. We're talking about 2018 taxes payable in 2019, when the applicant admits that he lived in that property the whole year. So I'm not sure, honestly, that the closing documents, they would have addressed the 2017 taxes payable in 2018, but I don't think they would have looked a year in advance.
Don't they automatically escrow those as of the date of sale?
They usually escrow the taxes for the year of the sale that are payable in the following year, so that would have
Right.
been the 17 taxes payable in 18. But here we're talking about the 18 taxes payable in 19. So we're not talking about the year in which he only owned the piece of property for 1 month. We're talking about the 2018 year, which I
Okay.
didn't understand at first.
I-
We're talking about the time period where the applicant lived in the property the whole entire time.
Sorry, I had that confused in the explanation.
Just for clarification, the 2018 taxes payable in 19 are based on the November 17 assessment, though.
Right.
Correct.
Yeah, okay,
November 1.
okay.
That's part of the confusion, I think. So,
It does get confusing. We deal 3 and 4 years sometimes. That gets very confusing. Sometimes I gotta flow chart it all out just to keep it straight in my head.
further questions? All right, thank you. I think I'd be looking for a motion.
Sure, I'd make a motion to deny this abatement request, and I'll comment, I guess, after that.
Is there a second?
I'll second it with a question.
Okay, we've got a motion and a second with lots of comments and questions.
Well, Madam Chair, taxes were assessed, taxes need to be paid, and if there was a screw-up at the closing, certainly I think that others have some responsibility. But we have the responsibility of collecting the taxes on every property in the county. And if we choose to let people get by with it, everybody else pays more. There is no period during this occupancy where protections of county government were denied this person. And we need to collect taxes. If he needs to go back to the seller or back to the title company, fine. But our job is to collect the taxes.
Commissioner Karski.
My question is, the abatement requested is $995.50. How is that calculated?
Okay, I'm going to speak for the auditor's office again, if they don't mind. But Mr. Etreim said he would be willing to pay the taxes if he could be billed as an owner occupied, meaning he would have owned it, occupied it on November 1. So based on that conclusion, what I gather from the auditor's office is she calculated that abatement. What would be the difference if he would have been owner occupied, since that is kind of his formal request?
But he didn't owner occupy.
He didn't
till
owner
December
occupy
4th,
it.
and the requirement is November 1st.
Correct.
Gotcha.
Go ahead, you can make a comment.
To that, yes, I did live in the property all of 2018. I was assuming I was gonna have to pay property taxes, so that's why I was willing to pay based on owner-occupied status, because I lived there the whole year. You know, I think they went outside of the assessment period, well outside of the assessment period. That's why I felt like it was reasonable for me to be allowed owner-occupied status after that November 1st deadline of when you live in it. I mean, I thought that was a reasonable compromise to the situation, but I guess it was after I moved in after that November 1st date, so I couldn't. But they also gave me an assessment well after the legal assessment date too, so.
Commissioner Heiberger.
I have one more question about the owner occupied status. When did you file your owner occupied status? Did you file it?
I
at
couldn't
December?
file it for that year. I mean, based on the document and how it's written, I couldn't file it, so I wasn't gonna file it, because there are whatever criminal complaints or something that you can be charged civilly,
But did you turn the paperwork in?
I have for this year.
Oh, but you didn't turn it in when you bought
well, I
the
couldn't.
property
I
in
mean,
17?
Certify you were occupying it on November 1st.
Yeah, I wasn't gonna lie about occupying it on November 1st when I didn't,
Oh, I
guess.
have one more question about that, because did you own a house before? You were living in a house before, so you had owner occupied status someplace else?
No, I lived in an apartment before.
All right.
Chris, would you come up and explain the whole owner-occupied issue here as it applies to this particular situation?
Sure, yes.
Thank you.
We do have him applied for 19 due and paying 20. The 18 due and paying 19, that's the year in question. Again, he had to own it and occupy it. It had to be his principal residence, and he can only claim one as of November 1 of 2017. He didn't purchase it until December 4th. There's nothing in the state law that allows us to grant owner occupied due to that. But again, moving forward, we have got his application. We do have him owner occupied for the 19 due and paying 20 year.
Which I think is similar to an issue we've looked at before. If he'd bought a house that had been occupied, then he would have been eligible for
There's a
owner.
potential that it could have carried forward. Yes, that is transferable. On a spec home, a new home, now there is another option that Marlon Conrad, and we're past the time of that now, could have potentially, if he holds a contractor excise tax license and he was a builder and he was building a spec home, there is the contractor owner occupied law in place. We never received any applications from him. That would have transferred over to Mr. Etreim, but again, I can't give something I don't have. And I can't even say if he's a contractor. He could have just owned the land and hired a contractor to come and build a spec home for him to turn around and sell. If he doesn't hold a contractor's excise tax license, he himself is not eligible to apply. It's only for contractors to build and get up to 4 houses that they're own and sitting on, so they can mitigate their risk in the event they don't sell right away.
Comments, questions?
I'd say this is a mess, and that this is something that should be looked at by the legislature, because other people buy houses November 7th or November 8th.
November
And they
2nd.
go a whole year without owner-occupied statuses, and this is something that maybe we should look at to bring forward as a cleanup act.
Yes.
As legislation, because this is, I mean, especially because new homeowners are usually young people.
And I'm actually
Not
going
always,
to
but-
meet based on a previous abatement request with the city tomorrow. They've asked that I come to their meeting to discuss any legislative action or changes to that. My only issue with the owner occupied is, where do you put a line? It doesn't matter what date you put on it, there will always be somebody that happened the next day. Legislature right now said November 1 is our date. How did that property stand today? That's for my assessment, that's for ownership, that's for living there. Everything is wrapped around that date. We can discuss it further at another time, but I don't know where or what we would do, so.
And I mean, I'm going to support the denial of the abatement, but want you to know I sympathize. I don't think your request is unreasonable. This whole owner-occupied thing has been something that we have been struggling with recently, and while some of this might not seem all that clear, it is pretty clear because we vetted this out that we do not have the authority under state law to grant owner-occupied in a situation like this, which is very frustrating for us. And I do think that that is something that we need to look at. So, any other questions or comments? Okay, roll call vote, please.
Barth,
Aye.
Benega,
Aye.
Hiberger, Karski,
Aye.
Bender.
Aye. Motion passes unanimously. Okay, so that takes us to item 7, notices and requests. Consider, the next item is to authorize the auditor to publish notice of a hearing on July 30th, 2019 for an annual retail on-off sale malt beverage and South Dakota Farm wine license. Olivia.
Yes. We received an application from the Isaac Walton League. They would like to get an annual malt beverage and South Dakota Farm wine license. So this is just me requesting that we set the hearing date for July 30th and authorize the auditor to publish that notice.
Any questions?
Move to set the date of hearing.
Second?
Motion and a second. All in favor?
Aye.
Aye.
Any opposed? Motion passes unanimously. Thank you. Item 8, planning and zoning notices. There are none. Item 9, petition for compromise of lien. Melinda Storley, good morning.
Good morning, Melinda Storley, Commission Assistant. Attorney James Simcoe, he's the representative for Leroy and Sharon Bobcat, is requesting a compromise of lien for DPNO 41076 in the amount of $2,424.35 with no payment, only as it applies to the property legally described below with a street address of 814 South Jessica Avenue, Sioux Falls, South Dakota, leaving the lien in place and in full against the individuals named on the lien. His clients, the Vockrods, owner of the real property, entered into a contract for deed with the lienee and her current spouse on June 22nd, 2009. The lien was from 1999 to 2003 and attached to the property when the contract was recorded. The buyers have since defaulted on the contract and have also failed to pay property taxes for several years. A complaint for foreclosure of real estate is pending filing with the Second Judicial Circuit Court at this time. There is no intention of seeking release of the property taxes. They will be paid off. The action requested today is to consider a motion to release lien DPNO 41076 in the amount of $2,424.35, only as it applies to the real property with no payment. Again, leaving the lien in place and in full against the individuals named on the lien. Michelle Stratton from the law firm is here to answer any questions, if you like.
Any questions?
We've had several of these things come, and I believe precedent is that we release it. But I think this is another example of something we need to bring to the legislature. This party lived there for 20 years, made some payments, and suddenly they move out and you know, we lose whatever leverage. Obviously, the owners under the contract for deed, you know, didn't do very well in picking a buyer. And I think that maybe, you know, the law should be that if you live there for 5 years, you know, and the property goes back to the seller, that you are liable for that. I think 20 years, I mean, some people pay off their mortgage in 15 years. What did they do with all that money over those years? Of course, that's not my business, and precedent is that we forgive this and give the property back to the original owner without this debt, and I would make that motion.
Second.
Motion and a second. Any further comments? Roll call vote, please.
Benega?
Aye.
Hiberger?
Aye.
Karski?
Aye.
Barth?
Aye.
Bender?
Aye. Motion passes unanimously. Thank you. Next item.
This is 3 liens. The action requested here is to consider a motion to compromise 3 county aid liens for the petitioners. One is DPNO 42597, the other DPNO 50416, and DPNO 87060, with a combined balance of $4,682.62, and release the liens in full with payment of $2,000. The petitioner and her spouse are in the process of purchasing a home for their family and are expected to close on July 12, 2019. They were aware of the liens but believed that bankruptcy proceedings in 2016 had eliminated them. The petitioners are requesting release of the 3 liens in full upon payment of $2,000. They have included a narrative explaining their circumstances. The liens represent rental assistance, public defender, public advocate, and court-appointed attorney fees. Payments toward lien DPNO 42597 total $912. No payments were received on the other 2 liens. The petitioner claims assets of $11,393, liabilities totaling $6,000. Of course, you had the 2018 income tax and 2 most recent paychecks for your review. The closing costs for the home purchase will be provided by her parents to help assist with her making money available for paying the $2,000 toward the lien.
Questions?
The petitioner is available if you have any questions for her.
Okay. The applicant, if you're here, you don't have to identify yourself. You don't have to come to the microphone. If there's anything you want to add or say, you can certainly do so.
All I really like to say is, if I didn't have to come here to do this, I wouldn't, and I didn't know that a lot of it didn't get taken care of. If I would've known, I would've just taken care of it myself. So coming into buying our first house with our children and having it come up and potentially not be able to get our first house, kind of, is a little stressful. So we come up with that $2,000 as well as trying to help my dad with the closing costs in the last 4 weeks. So I really don't know what else to say about breaking down.
Fine, that's fine. Thank you. Comments, questions?
Madam Chair, I would just comment that while we could ask for a greater amount of repayment, some payments have been made. I like that. The fact that some of these were for court-appointed attorneys, et cetera, I don't like that. But this family will be back paying taxes after this transaction, and I think there's a great benefit to that.
Commissioner Heiberger.
I'm going to support the compromise. She's more than paid for her public defender expenses with her, what her payments are in the future payment. And the rest of these things were for rental assistance or poor release assistance, and that's what the county is here for.
Anyone else? Commissioner Karski?
I'd like to make a motion.
Okay. When you make your motion, if you could state, if we're going to take the recommendation, then what I would like is to be specific that the $2,000 be applied to the first lien, DPNO 42597, so that we can make it easier for the auditor's office and then that the other 2 would just be released in full.
Okay. Well, I'd like to make a motion to compromise the 3 county liens with a payment of $1,000 to be applied to DPNO 42597.
I'd second that motion.
So only $1,000.
Correct.
Just want to make it clear. So we have a motion and a second. Any other comments? Roll call vote, please.
Hiberger?
Aye.
Karski?
Aye.
Barth?
Aye.
Benega?
Aye.
Bender?
Aye. Motion passes unanimously. Good luck. All right, that takes us to opportunity for public comment. This might,
Long delayed.
I was going to say, this may be a record for the longest it has taken us to get to public comment, so we apologize for you having to wait for so long. If you just identify yourself and your name and your address, please.
Okay, good morning. My name is Jim Reef. I live at 5904 North Swanson Drive, Sioux Falls, South Dakota, 57107. Chairperson Bender, members of the County Commission. Last week I had the opportunity to come to the Commission office looking for help, direction, guidance regarding an issue in our housing development. It's called Swanson Tracks, located in Mapleton Township, just north of Skyline Heights. Commissioner Barth was there, came to my aid. He intently listened and understood my dilemma, or I should say, a county dilemma. For the past 5 to 8 years, since a rather rude and boisterous individual and members of his bikers gang moved into our housing development, and unfortunately across the street from my family, we've endured loud noise from late parties, fireworks during the approved period as well as other times during the year. Late parties, loud noise from my motorcycles revving up in the yard, tearing up and down the gravel road, and going into the early morning hours. The individual is now deceased, but his wife is still there, and members of the gang still are present. Initially it was the Banditos, now it's the Cossacks. Am I fearful for what is happening? Yes. In part because last year a call was made to the County Sheriff's Department, which, by the way, they handled extremely well. A projectile came from, I suspect, a miniature howitzer that he has in his front yard. It came and it ended up hitting a dwarf evergreen that I have approximately 4 feet away from my house. If it wasn't for that evergreen, which burnt to the ground, it would have ended up hitting my natural gas meter. So instead of standing before you, it could have been 5 people listed in the obituaries of the Argus Leader. I am concerned about my safety as well as members of my family. And the reason that I say this is a county dilemma is because there is no ordinance for noise. I realize there's nothing that can be done regarding fireworks as long as it's within the period. I know some of you sympathize with me, but what I'm not asking you to sympathize with me. I am asking you to consider the noise ordinance, which there is none. Years ago, the county, you ended up having farmers, lived mile away, so fireworks was no issue. Loud noise was no issue. Today there are many housing developments in our county. I believe there's, in Mapleton Township, there's some 17 housing developments. So the makeup of the township, of the county, is different than what it used to be. There are people, I know a number of them have moved out from the city because they either don't like their neighbor or they like to raise, hell. I would request that you reconsider, for the purpose of the livelihood of those people living in housing developments, the consideration of a noise ordinance, deterrent, whatever you want to term it, to end up giving the residents a means of contacting law enforcement, as well as law enforcement having the opportunity to say, you're breaking the law, you need to stop this. Whereas right now, there is nothing. You go to the, as the Sheriff's Department has done in the past, you go up to the house and you ask them to tone it down. They don't have to. There's nothing. My grandson went through his second major surgery in a month, a few days before the 4th of July. Normally, they end up going into the wee hours of the morning, and I'm talking 2, 3 o'clock in the morning. This year, it was tamed down. It was done by midnight. So my purpose in coming before you is somewhat to provide information, but also to realize that noise is an issue. You end up having farmers, dairy farmers, their herd may not provide the milk. You end up having children that are trying to sleep because of school, yourselves that go to work the next day, or for those of us veterans that may be suffering from PTSD. So I thank you for the opportunity to speak before you, and again, I just ask that you consider something to help us residents as well as law enforcement. Thank you.
Thank you. Thank you very much. Is there anyone else here today for public comment? If not, that will take us to regular business. Item 10 is consider a motion to declare the red shed at the Sioux Empire Fairgrounds as surplus for destruction. Carol Muller.
Good morning, Commissioners. Carol Muller, Commission Office. Yes, before you today is a request to declare the red shed at the Sioux Empire Fairgrounds as surplus for destruction. You have done this in the past with the fairgrounds when they've got some very tired buildings that have no use, and in some situations, as this red shed is, you can see some of it's falling down. And Split Rock Fire Department has stated that they would like to use that for a controlled burn and training exercise. So the red shed was moved 4 years ago, probably, at the time when the new comfort station was put up. That was the original location for it. So before you today is the request to declare that surplus.
Questions for Carol?
Chair, it looks like it's fallen apart without our permission, so I'll make a motion to put it up to be destroyed completely.
Second.
Motion and a second. Any other comments? All right. All in favor?
Aye.
Any opposed? Motion passes unanimously. Thank you. Next item are liaison reports. Are there any liaison reports this week? Commissioner Karski.
Just a little bit late, but once a month I go to a meeting of the Lincoln County Economic Development Association and the Minnehaha County Economic Development Association, and we're updated on what's happening throughout the communities within the two counties. They put out a very interesting and detailed report that's available on the Makita or Lakita website. If you'd want to know about the MSA, the 4-county area, the 2 counties, it breaks it down. Everything from number of flights from the airport, commercial flights, amount of cargo, and that type of thing. But if you also just want to dial it down to your community, and I'll skip over Lincoln County because we're Minnehaha County. And if you want to look at what happens, Baltic, what's the average age, what's the daily commute, who is employed where, what are their population projections, all sorts. It's a lot of very interesting information that if a business is looking at relocating, that they're the type of information they're interested in also. But it is public information. It's just one of the things as members of Makita that is, we pay for through our membership, but it is some good data and it is very useful data, and if anybody's ever interested in it, it's out there for you. So just so you're aware of it. So.
Thank you. Thanks. Anything else? Okay. Any new business?
Madam Chair,
Commissioner Barth?
I think we should consider looking into noise ordinance insofar as there are residential developments in the townships, and maybe we could consult with the townships as to what their opinion is.
Right. Commissioner Karski?
It's interesting, Commissioner Barth, last night visiting with one of my neighbors who happens to commute to he farms with his son out by Canastota, mentioned, and if you travel through South Dakota, the Jake brakes or the engine braking is not permitted, coming into a lot of these smaller communities, and I'm not aware of anything like that really surrounding Sioux Falls, which would be part of a noise ordinance. So it was just brought to my attention just last night by a taxpayer. So I would agree that, and noise ordinances are such a hard thing to enforce, you know, decibel levels for certain extended time periods, et cetera, but to the point of the public comment, at least if you have something, you can say, hey, we've had a complaint, can you tone it down a little bit without going to the whole extent of measuring noise and that type of thing. At least gives you a little something to fall back on.
Anything else? Any old business? Commissioner Barth?
Last week, Madam Chair, I brought up the idea of the larger disasters that we seem to be happening more frequently, and the idea of hardening our infrastructure. And interestingly, after the 2 earthquakes in California, they're talking about upgrading their infrastructure out there. You know, even if it's just something like building our bridges so there's more clearance underneath for floodwaters to pass through, putting in larger culverts so that it's not ponding on one side of the road or the other. I think the way things are going, and any of us that drove here today are reminded of the old question, how many animals of each type did Moses take on the ark? And of course the answer is none. It was Noah. But let's plan on trying to build for a stronger infrastructure in Minnehaha County.
Okay. Anything else? All right, if not, I'd entertain a motion to adjourn.
Motion to adjourn?
Second.
And all in favor?
Aye.
Any opposed? Motion passes unanimously. Thank you, everyone.